Hello, everyone. Welcome to Court with Krissy. Perhaps we need to practice. Say it with me now. Con, contempt. It's not that hard, but sometimes the truth can be sad. Two different clips, and I hope you like them both. Court with Krissy is now in session.
Welcome back. We're on the record again in case 24-4395FY. And before I continue on, Ms. Claxton, I pulled this matter up in our system, and there is another bond violation allegation. It is, let's see, it was signed by Judge Stepka on August 29th. It's a statewide pickup for a no bond, and it alleges, find this in here, it alleges that Ms. Stingley failed to appear for a benchmark urine screen and has not downloaded and maintained the Court Fact app. Do you need to go back in the breakout room to discuss this with her?
We did discuss the drug screen. I guess if we could briefly discuss the Court Fact app, that'd be great.
Okay, and then did you see that the bond violation that was emailed to you, that was the bond violation that I was aware of?
Yeah, we did review that one.
Okay, very good. Thank you. All right, so I will open up the breakout room again, and I'll speak with you when you come back.
Thank you.
All right, welcome back. We're on the record again in case 24-4395FY. Ms. Claxton, did you have an opportunity to discuss this case with Ms. Stingley?
I did. We reviewed the charges, the maximum penalties. We'll waive a formal reading. She'll be pleading not guilty and requesting court-appointed counsel. We also reviewed the alleged bond violations. It sounds like she would waive her right to a hearing as to the Court Fact app and the missed drug tests. However, the other allegations, she would plead not guilty and ask for a hearing with her attorney.
Okay, thank you. All right. I do want to remind you, Ms. Stingley, that you have the right to remain silent. Anything you say orally or in writing may be used against you in court. You have the right to a trial, and you have the right to the assistance of an attorney and to have an attorney present for all questioning and any subsequent court proceedings. If you cannot afford an attorney, the court would appoint one to you at partial public expense. I do need to complete a petition with you, so I'd ask that you raise your right hand so I can swear you in. Do you swear or affirm that the information you're about to give me is the truth to the best of your knowledge?
Yes, ma'am.
All right, very good. Thank you. What is a good mailing address for you when you're not incarcerated? Do you have a phone number you use? Thank you. Do you use email?
Yeah, I have. I'm not real good at the email thing, though. I'm not real good at the new technology stuff.
That's okay. Thank you. I appreciate you saying that. Okay, and let's see here. What's your living arrangement? Do you live with others? Do you have a rental, a mortgage?
I stay with my family right now. I just left an apartment, but I have all my belongings is in storage. I just started a job at the Cherry Tree Inn. And I also was scheduled to start counseling tomorrow with Munson Behavioral in Traverse City.
Okay. All right. Thank you. What's your legal marital status?
Never been married.
Do you have any minor children or dependents you support?
No.
And the name of your employer again, please?
It's a Cherry Tree Inn.
Thank you. Do you have any other source of income or support?
No.
Do you own any real estate or vehicles?
I own a vehicle.
What's the approximate value of that vehicle?
Maybe 3,000.
Do you have any money in a checking account, a savings account, any cash on hand or digital currency?
No, ma'am.
Thank you. All right, I am going to appoint an attorney to you. He or she will be getting in touch with you in the next couple of weeks. And the next step in the process is going to be a probable cause conference. That'll be scheduled for October 9th. And we'll also schedule a preliminary examination for October 16th. We'll get that paperwork sent to you so you have a copy of it.
What about reinstating the bond, ma'am?
We're going to get to bond in just a moment.
Right.
All right, we'll put down here, we'll ask that the judge handle the bond hearing on October 9th at the same time. Okay. Let's see here. Ms. Claxton, is there anything you want to tell us regarding bond before we move on?
Yes, thank you. In speaking with her, it sounds like as far as the drug testing goes, she didn't have any money at the time to pay for the drug test. She is now employed and have that money. She indicated also that her mother is now also on board to help her out. As far as the court fact app, she stated that she didn't know what that was. So I think that was just a miscommunication that she didn't understand. She is, like I stated, employed. It sounds like she originally did pay a bond, and she is going to be starting outpatient therapy with Munson Behavioral Health tomorrow. So we'd ask that the court consider reinstating her bond at this time.
Thank you so much. All right, Ms. Truesdell, is there anything the people wish to weigh in on?
Your Honor, I'd only remind the court that she is charged with 2 very, very serious felonies, which could result in substantial prison time. And there has been a previous bond violation for failure to appear, which resulted in a statewide pickup with no bond. So being as how she has requested a court-appointed attorney and a hearing on the bond violation, I'd ask that she be remanded pending the hearing.
Thank you, Ms. Truesdell. All right, let me get in here. So just looking over this paperwork, I am the one that originally set your bond
Yes, ma'am.
and gave you the instruction to contact Community Corrections to
I just,
download, maintain the Court Fact app. So I know you did know.
I just wasn't sure what that was. I was just assuming that it was still just part of the drug test, I guess.
I know I went over it with you, and at the time you did acknowledge to me that you understood the terms and conditions. But as for now, I am not going to reinstate that bond. I am going to remand you pending the next step. And at that time, you and your attorney could seek to have bond reinstated, okay?
I mean, I guess, so there goes my job and everything. Everything I own, I'm gonna lose everything I own.
Ms. Stingley, you had opportunities. We're not going to get into the nuts and bolts of the case or what happened. It's just something you did or didn't do is
I'm just
the
asking
consequence of why
for-
you're here today. So I'd like you to let the officer know that we're all set. Okay, I'll send some paperwork over to you.
Fuck you. Fuck you.
Ms. Stingley,
Yes, ma'am.
please come back over here. You will not speak to me that way in my own
Ma'am, I
courtroom.
wasn't talking to you. I was saying just fuck to me. Just, I'm sorry. I'm sorry. I didn't mean to say it when you were still there.
This is not the venue to use that kind of language.
I understand, ma'am.
Okay, please let the officer know you're all set.
Yep.
Folks, good morning. We are on the record today for the 28th Circuit Court here in Wexford County. And we're going to begin the next session here by taking up the case of People of the State of Michigan versus Zoe Davidson. This is file number 24-13743FH. Appearances, please.
Joanne Carey, Chief Assistant Prosecuting Attorney for the people.
And I'm Jeff Harrison. I'm here on behalf of Zoe Arizona Davidson. She's on the video.
Again, Ms. Davidson joins us today via Zoom from the Wexford County Sheriff's Department. Ms. Davidson, are you able to see and hear us?
Yes, Your Honor.
Thank you, ma'am. The court also recognizes before today Mr. Brian Potter, an agent from the Michigan Department of Corrections, and is the probation officer on this case. Madam Clerk, I'm just going to highlight for you on the last order that we had here from last week. You'll see that they must have taken one from the previous portion of the case. It listed, quote, defendant pled guilty. Now, it wasn't checked, but it said defendant pled guilty to violations counts 1, 3, 4, 5, and 6. Well, there clearly isn't that number of charges here. We're here today on the informal hearing after an arraignment last week on a request and warrant for a probation violation. That request and warrant included a single charge for use of the controlled substance methamphetamine. Mr. Potter, I don't recall, but have there been any updates or amendments?
No, Your Honor.
Thank you. Mr. Harrison, what are we doing with the file today, sir?
It's my understanding that Ms. Davidson is prepared to make an admission today.
All right. Ms. Davidson, I'm told by Mr. Harrison today, your attorney, that you intend to admit to the use of that methamphetamine. Before I ask you any questions, please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, ma'am?
Yes, Your Honor.
You may lower your hand. Ms. Davidson, do you intend to plead guilty to this single count?
Yes, Your Honor.
If you plead guilty and the court accepts that plea, you will not have a hearing or a contested hearing of any kind. If you plead guilty and the court accepts it, you're going to be given up the right to have that contested hearing, have the prosecutor prove the allegations by a preponderance of the evidence, to question and cross-examine any witnesses presented against you, as well as the right to present witnesses, evidence, or testimony, or have the court order witnesses to appear on your behalf. Also, you'll be given up the right to remain silent and not have that silence used against you at a hearing. Again, I remind you that if you are found guilty of these violations, you will be resentenced on your original offenses. As we spoke last week, you were convicted of attempted assault, resist, obstruct a police officer, which is a misdemeanor punishable by up to a year and or up to $1,000, and guilty of possession of controlled substance methamphetamine, which is a felony punishable by up to 10 years and or up to $15,000. So far, do you understand, Ms. Davidson?
Yes, Your Honor.
All right. Now, I know we discussed earlier your prior issues on probation and the prior number of technicals and non-technical, and how that could impact the maximum sentence or punishment that the court may issue. Do you need me to repeat any of that we discussed last week?
No, Your Honor.
Thank you. And again, if you are found guilty of this violation based upon the plea and the original information, any appeal would be asked, would be by filing an application for leave to appeal, not a claim to appeal by right. All right, Ms. Davidson, as to the single count that you violated your term or condition of probation 2.4 that required you not to use any controlled substances, and more specifically that on or about September 18th of this year, you used methamphetamine. How do you plead?
Guilty, Your Honor.
And Ms. Davidson, did you know that you were required not to use illegal controlled substances while on probation?
Yes, Your Honor.
And did you on or about, or maybe the day before, use some methamphetamine on September 18th of this year?
Yes, Your Honor.
In your mind, did you have any right or lawful right to be able to use that substance?
No, Your Honor.
Thank you. The court also takes judicial notice of the terms and conditions of probation that are contained in the court file. They were issued by me on May 23rd, 2024, and then subsequently acknowledged by Ms. Davidson on May 28th of 2024. Ms. Carey, do you believe the defendant provided a factual basis as to the single count?
I do.
Mr. Harrison?
I do as well.
Ms. Carey, are you aware of any promises, threats, or inducements that we haven't heard about?
I'm not.
Mr. Harrison?
Nor am I.
And Ms. Carey, do you believe the court's compliance with the court rules?
Yes, sir.
Mr. Harrison?
Indeed.
Ms. Davidson, I forgot to ask you one question. Has anyone made any promises, threats, or duress towards you to get you to plead guilty to this?
No, Your Honor.
All right, thank you. Well, the court finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record, in addition to the judicial notice taken of the terms and conditions that are contained in the file, satisfy the elements. Therefore, the defendant is found guilty of the single count on the requested warrant for the probation dated September 19th of 2024. All right, so let's move to the next question of potential sentence. If I recall, Ms. Davidson had some other prior probation violations. Is that correct, Mr. Potter?
Your Honor, those counts that you referred to earlier, the 1, 3, 4, 5, 6 were the counts in a prior violation that she had been found guilty of.
And what was the last sentence that we had?
It was in May where she had lost her 7411 in her HIDA and was given the new probation terms. And that's the probation term now that she's on.
Right, and was the last sentence the one on May 9th?
Yes, Your Honor.
Yeah.
And that was 120 days.
Yes, Your Honor.
Okay, thank you. One moment, I just take another look here. All right. Are we able to proceed to sentencing today, Mr. Potter?
Yes, Your Honor.
Ms. Carey, any objection?
No, sir.
Mr. Harrison, any objection?
None.
Ms. Davidson, we're now going to move to the sentencing phase, and I need to tell you that you have the right to be physically present here in the courtroom today or someday before the court gives a sentence. Or you can waive that right and allow us to conduct sentencing with you there via Zoom. Do you wish to be brought here in person?
No, Your Honor.
So you will waive that right and allow us to conduct it via Zoom?
Yes, Your Honor.
I find pursuant to the court rules that the technology is available and sufficient to allow us to conduct the hearing. Mr. Potter?
Thank you, Your Honor. 1 second, Your Honor. I just want to look at one thing. Your Honor, as just stated to the court, the defendant was sentenced on 5/9/24 to the attempted RNO and the controlled substance possession of meth, a 1 year and a 10-year. The defendant had originally been granted HYTA by this court in 7411. Both of those were revoked at that time, and the defendant had pled to 5 of the 6 counts of probation violation. Your Honor, the court imposed 120 days of jail credit for 23 days. So at that time, she had approximately 77 days to serve. So if my math does me right, she's been out of jail about a month, and she's back to the same behavior that she just sat 100 days in. Your Honor, with that, we feel that probation is going nowhere with this case. We ask that it be revoked. Guidelines, Your Honor, were 0 to 9. Current credit as of today will be 103 days, 103. Your Honor, I'll leave. I'm not going to make a jail recommendation. I'll leave it up to the court.
Thank you.
Your Honor, I would, I agree with Mr. Potter. I don't believe that Ms. Davidson is going to be supervisable, and she's certainly shown that she is not supervisable. The people would request 270 days.
Mr. Potter, I know she scored 0 to 9. She must have had at least some prior criminal history to get a 0 to 9, maybe a couple misdemeanors.
Your Honor, that's what I was actually looking for when we first started. I wanted to verify. We have no, Your Honor, it shows 0 on the prior record scoring, so I'm going to the actual criminal history.
Well, she wouldn't even have had any juvenile issues then.
I do not see prior history, Your Honor.
How old is she right now? Prior history. 23. Mr. Harrison, on behalf of the client.
I don't know. I don't have any good answers here. Neither does Zoe. We had a very emotional visit on Friday. It was difficult for both of us. But I found a positive spin to put on it because she is at the point now where I think she's receptive, at least to the concept that she's the only one that can make her situation better or right. I think there was a tendency on her part in the past to probably due in no small measure to her young age that she tended to project this and tended to think that it was other people's fault and that it was the other people she was with that had led her astray. Friday, her demeanor was, look at what I've done to myself. And it was kind of hard to watch her go through that emotionally, but at the same time, there was a part of me that said, thank God. The light bulb has gone out. If this were a cartoon, there'd be a giant incandescent bulb flashing over her head because I think she's now at the point where she's tired. She's tired of going to jail. She's tired of living like this. The astonishing thing to me was, yeah, her overall lack of criminal history. And I think it shows. Yet again, the grip that methamphetamine can have on someone without them really even knowing it. And I think that realization needs to occur before someone can successfully deal with whatever extent of problem they have with methamphetamine or whatever their drug of choice is. So I realized that 0 to 9, I understand a resort to the top of the guidelines, the termination of it's hard to argue against that given the track record here. I wish I had had that conversation with Zoe perhaps like a year ago before her last jail stay, and that she would have been able to focus her attention on staying clean, which I think she can now, ironically. I don't know. I don't have answers. This is a hard case for me because I know two things. I know she can't stay out of her own way. That, like Mr. Potter noted, she was out of jail for a month and used. On the other hand, I believe her when she says that she's trying. I don't know what to say about this generation. And I know I sound like my grandfather when I start talking like that.
I'm sure they talk that way about us.
Exactly. So it's not news to the court that there's this pervasive attitude amongst younger people, and a number of whom are released into the world when they turn 18 years old and they're legally an adult, but not psychologically, and they're asked to cope with things that we didn't have to deal with. I can only imagine what my generation's response to such stimulation would have been. That's all for speculation here, but I think it gives some insight as to where I think her thinking is aligned now. I can argue against, I can't say that a 270-day jail recommendation is outrageous. I can't. It's within the guidelines. It would certainly be a reaction to the frustration, a reaction to the fact that she failed miserably at this round of probation. But I leave that to the discretion of the court with the understanding in regard to some of the other things that I've been told this morning. Thank you.
Mr. Potter, I know that last time we dealt with some probation violations where she wasn't seeking or didn't seek any treatment. Did she get any for the 1 month she was out?
Your Honor, she's been supervised by Agent Blazek over Misaki County, and I tried calling him this morning, but he is out of office.
All right, Ms. Davidson, you have the right to make a statement. Now, typically, I just sit back and allow the defendant to make the statement if they choose to do so. I'm going to tell you and explain something to you to make sure you understand it. And hold on, I'm going to give you. I generally do not, and I definitely do not want to ever seek that I am bargaining with the defendant on the sentence. What I'm going to give for confinement time is already in my head, most likely. And I want to highlight one thing. Mr. Potter recommended termination of probation, if I recall, right?
Yes.
And the court can terminate probation. A defendant can choose to say, I want a jail term in lieu of probation. And sometimes defendants do that and because they have the right to. They have to want to participate in rehabilitation and the probation terms. And sometimes I have defendants who actually want to stay on probation because they need that carrot and stick and supervision to help them. Do you wish to remain on probation? Some people say no, some people say, yeah, I want to take advantage of this. I want to continue whatever I had started, if you had started anything. What is your thought about probation, Ms. Davidson?
I just want to say to the court that I obviously need help, and I'm a 23-year-old young mom who has 2 babies, and this outpatient care treatment bullshit isn't working. And I don't want to be like, no offense to the court, but I don't want to be like my sister and continue down the road I'm going down. Like, I think I need something more intensive, and I need help. Like, I didn't try NMRE when I was in here the first time, and it was just, I've been paying my fines. I owe like $1,000 to Wexford, and I paid a huge chunk on that. I've also paid a huge chunk on my Misaki County fines that I have. It was literally just an oops. Like, like I'm not a bad person. I want to do right and do good. I need help, and I'm strong enough, old enough, and have the power to say that I need help and want help, and I don't feel like jail or prison or a rehab that I can just walk out of is gonna help me. Like, I need help, and I've asked for help, and I'm gonna continue to ask for help, and like, this just sucks. Like, this sucks, and I don't like to be in jail.
All right. Thank you, Ms. Davidson. Madam Clerk, she has made some payments.
She's made $550.
Good. All right.
And I continue to still pay on my fines too.
I know. All right, so here's what I see. It is really easy to, and sometimes I've done it, sometimes I want to do it, and cut the person off and kick them out of probation and hit them with a stiff jail sentence. Especially when they've got long criminal histories and they've had multiple opportunities. Now, I also will note that I've seen Miss Davidson a couple times, maybe in this case only. It must have been this case only. And I have seen some change in Miss Davidson. I've seen where she's presented the best word I can come up with is an attitude, which, by the way, if anyone's ever had a 22, 23-year-old son or daughter, they know that attitude. And I'm not saying that to be mean, because what I'm going to try to say is this Miss Davidson and the one I saw last week on the arraignment, I think is different. I'm not going to say she's learned her lesson entirely, but I'm just going to say I think she's different. She didn't cop that attitude that I have in my head when I hear the name Zoe Davidson. So I don't know if I'm a soothsayer, but part of our job here is not merely about punishment. Now, when it comes to rehabilitation, and we had a meeting last week with the AG up here, we talked about opioid money, and I know this is not an opioid case, but I spoke and made it pretty clear that we can provide programs out there for people who need help, but often people don't seek help or want help or get help until they have a stick hanging over their head. So I do believe that some jail time is appropriate, but at the same time, because she's a young person and because she's a young, and because I want to see Miss Davidson get through this and not come back to court for more criminal trouble. I think Miss Davidson, coming from an older guy, is in a position where this is a point in her life. She can choose one direction and keep coming back in front of the court, or she can choose the other direction and keep going forward. Let's hope she chooses the other direction. By the way, if she doesn't and continues to keep getting arrested and sees probation violations, any judge is going to look at it and go, yeah, this person likely needs more and more confinement. So it is a sentence of the court today that the court will continue probation as previously ordered by this court. The court preserves all fines and costs. I do think some period of confinement is appropriate. And I looked here at the last sentence, and the last one was 120?
Yes, sir.
All right, so the court's the court issues a sentence of 240 days with 103 days of credit. While Miss Davidson is there in the jail, let's hope she starts to work with Catholic Human Services and Miss Cox at the jail. So that way, when she gets out, Miss Cox can help get her involved with Catholic Human Services to provide some continuing treatment once she gets out. Now, if she doesn't seek, yes, ma'am?
I'm already doing CHS and
Good.
I talk to Gail. I go in there and I see Gail every other week, and I mean it's all good and everything, but I think I need something more intensive. I need something where I can be put into and not leave and be worked with, because this CHS walking out and
I understand. Ms. Davidson, you are preaching to the choir. I would love to have a program here in Wexford County that I could order people into. I have talked about that ad nauseum with anybody who's an elected official in Lansing to listen to me and say that's what we need. But I have yet to see anyone start constructing a building here in town. But without a doubt, that's what we need. If the Department of Corrections is able to get you into a program that's an inpatient program, let's hope they are able to do so. If Mr. Harrison and the Public Defender's Office through the Indigent Defense Commission can do so, I'd let you out and send you to an inpatient program. Unfortunately, I don't have it. I know. Ms. Davidson, I know. I really hope this part of this saga gets you and puts you on the right path. Again, you're 23 years of age. That's less than half how old I am. So let's hope that this is a good learning point. And if we're able to find you one, I'm telling probation now, if they can get you into an inpatient program, I'll let you go early. I'm telling Mr. Harrison, if his office is able to, I'd let you out early. Okay? All right. Ms. Davidson, you have the right to appeal the conviction and sentence in your case. Oh, by the way, today's sentence applies to both counts. You have the right to appeal the conviction and sentence based upon the pleas. Any appeal must be done through filing an application for leave to appeal. If you wish to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you may complete the bottom half of the document that will be delivered to you at the jail and complete it, and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Ms. Davidson, let's use this time appropriately. You're a young person. You can change your life entirely. Mr. Potter, is there something you need to say?
Clarification, Your Honor, if we could. Generally, the residential treatment centers issue, they would go get on the phone immediately after sentencing, try to get a bed. They're only good for 30 days, and then we have a balance of jail time left. We generally only look at residential in the last 30 days of the sentence imposed by the court. Are you saying something different here?
Well, I understand that. What I'm just trying to say is, if anyone can get her into a program, I would modify the sentence. I would have to, by the way, notify the defendant. I'm sorry. I'm looking at Ms. Karen. She's not the defense attorney. I would have to notify the prosecutor's office, and if they agreed, I think we could do that. But if you can't until that period of time, then so be it. But I'm just trying to say, whatever we can do to get her into an inpatient program, I'll sign the piece of paper that makes it.
Thank you, Your Honor.
Thank you. All right. We're adjourned.
Thank you.